Hey everyone, it is your management team here with your management minute. Just yesterday, we saw a post, well, a news article came out, and then it came up in our WhatsApp chats. But this interesting court case around the PDS, the property disclosure statement, and it being crossed out. Um, what do we have to say about that, team?
Well, I'm just surprised that Phil Moore has not yet been on social media to give some very insightful thoughts, because you gotta love what he does there. Um, I'll weigh in again. Allison, your thoughts on that article?
Well, I mean, I think there's always trepidation when sellers are possibly advised or from us or legal about what do we do with this PDS because it's not mandatory, but we found that sometimes how we fill it out or what we might say could be a detriment in this case. Um, I'll go right to the end where the case Chambers submits that um, maybe we just don't fill one out. Just leave it. It's not mandatory. That's okay. But we also know in real life, the lenders need this to proceed with a mortgage. So we're a bit in a rock and a hard place. Um, but there was some interesting takes on what the cross out meant versus if there was no PDS, perhaps, and just maybe signed blank. Corey, you had a good take on that.
Yeah, well, I think, in our industry, I've always thought, and I think most have thought that crossing out meant that a seller wasn't answering those questions. Interestingly, one court agreed with that, and then an appeal court came and said, no, no, a seller not answering that means that they're saying they don't have the answers to those questions, which is a little semantical thing, but important when there's something like a potential material latent defect at play here. And then we get into the what's a material latent defect to a seller versus what's a material latent defect to a licensee. Did the licensee have cause to know about this issue with our higher standard of disclosure, the issues that surround that? So my takeaway is this. We always want to know black and white answers to things. This issue went to court. One court found one way, an appeal court found another. So even the courts don't agree on these issues. And before we hit record on this, Allison was saying, why not just disclose when these things are, should I not disclose? Avoid court 3 years from now and get that disclosure out of the way is my thoughts.
Yeah, and I got to circle back to the notion of where is the realtor in all this? Have you got cause to believe there was something that required an investigation to find out the permit issue? And so we should all sit back and evaluate, how often am I making those inquiries as a listing agent? Or as a buyer's agent, is there cause for me to make additional inquiries on my own, independent of what the listing agent has done? Lots to be learned, I think.
Every set of brokerages have probably a different threshold as to what a manager should get involved in. But let me tell you that us three love this stuff. So when you are dealing with this live, should we disclose? Is this an issue? What are our options? Reach out, and we'd love to chat to you about what your and your clients' options might be in moving forward. So, an interesting one. We'll post the link to the article about this case along with the videos so you can see what it is that we're talking about and you can consider it for yourself. And we'll see you next week for the weekly update. Thanks all.